The Honourable Deputy Speaker.
Honourable Member for Siparia, as we reconvene, you have 3 minutes in order to conclude your initial, and I can ask at this time, do you intend to utilize your additional 15 minutes?
I will, with your leave,
Right.
utilize the additional 15 minutes, and thank you very much.
Proceed.
Honourable Deputy Speaker, I'm very pleased to be speaking in your presence this afternoon as we continue the debate on the motion to resolve that we have lost confidence in the Honourable Attorney General by reason of his conduct in the handling of the Malcolm Jones matter. And when we took the break, Honourable Deputy Speaker, I had indicated that we do believe that the conduct of the Attorney General is such that is in breach of his oath of office, that reeks of political interference, that is in breach of the fundamental principle of the Constitution and of the rule of law, that is in violation of the separation of powers. And we were of the view that, in support of our motion, that the Honourable Attorney General be removed from office. Now, Honourable Deputy Speaker, there is a concern. As I was, just before we closed a few minutes ago, I raised the point of the failure of the Honourable Prime Minister to honour his word in complying with the undertaking given on the 18th of April to provide the House in the motion with respect to the documents and so on. And up to this point, we have not seen those documents, but there's so much in the public domain that there is sufficient coming out of the circumstances to ground our complaint against the Attorney General, and therefore to support the resolution we have placed before this House. Now, Deputy Speaker, you remember, it was only yesterday that the people of the United Kingdom voted to exit from the European Union. And this is a matter that is going to have consequences worldwide. The fallout and so on is still unfolding as the days go by. I think the pound is now the lowest it's been in 31 years. And members there, you've already seen other members of the EU deciding whether they could, whether they would stay or go. However, I wish to place on record that I do believe that the Brits are very resilient people, and they will be able to face whatever challenges may arise from this, and of course to take full grasp of opportunities. But through you, our question would be whether, for us in Trinidad and Tobago, and of course indeed in the CARICOM, have we given thought to the fallout that may accrue to us, and whether we have given consideration as to what is happening, because even there, they don't seem to have any idea themselves as to what will happen. So I am concerned for the people of Trinidad and Tobago. Given that we were a former colony, we have ties with that part of the world. And perhaps we may want to take a page out of their book with respect to a referendum. There are some controversial issues that may be better dealt with through a referendum. And I know that the Honorable Attorney General is speaking about the Caribbean Court of Justice. And there's some more of the view that the Caribbean Court of Justice, that Grenada is going to accede to that court, but that's not true, with due respect. What they've agreed to do is to go for a referendum to decide for whether they will accede to the CCG. So I'm just, I'll pass out with respect to world affairs that we may want to take a page out of their book with a referendum on controversial matters like the CCJ, maybe matters dealing with abortion rights, matters dealing with LGBTI now rights. Those are very controversial matters that may be decided. And I began earlier this evening about the Shakespeare, the poetry from Shakespeare about entrances and exits. I spent a little time on the entrance of persons who had been involved in the World GTL matter, which formed the subject of the court proceedings, which is at the heart of the matter being discussed in this debate today. And I just want to spend a little more time, Honourable Deputy Speaker, on what transpired when the Honourable Attorney General really placed his reliance, and again here in this House, he did it before, now in this House, put full reliance on the advice of Queen's Counsel, Mr. Winston Nelson. I've read it here, and in previous, when he made his press briefings and so on, had referred to those judgments, referred to that opinion. And let's look at that. The AG is brandishing this. The AG is saying, I'm relying on this, and this is the reason why the case was discontinued. That advice, Deputy Speaker, brings to mind what it is was being reviewed, and I raised that point by the AG in all of their time. It raises the question of how is it that the instructing attorney could state in unequivocal terms that he provided advice to the Attorney General, and then to say in clear and unambiguous terms that the Attorney General was seen it for the first time February 2016, on the 16th with the All Council meeting. And did the AG then, when he saw it for the first time, give due consideration to that advice? Quotes it to say that this is the advice that means that, look, we didn't have a case, the state didn't have a case. But that is not what that advice said. The advice said that there was a likelihood that the case could go south, that the case could go a certain way. There was a likelihood, and that it should be considered. But if there is a likelihood that it could go south, there's a likelihood that it could also go north. And therefore, there is a real tribal issue to go before the Supreme Court. So in itself, that advice, in my respectful view, does not give the Honourable Attorney General any comfort in terms of a defense with respect to his conduct and his action. We have all these correspondences the AG referred to, and of course we didn't have the courtesy from the other side to share these matters with us. And when we consider the advice provided to Petrotin, it does not, in my view, support the discontinuance of the matter. The advice is clear that this is the evidence in the trial and not the evidence in the witness statements and the arbitration that will determine the matter. But they would have us believe otherwise, Deputy Speaker. There is no real basis on which the witness statements will assist the defendant. These are the words of Queen's Counsel Vincent Nelson in his opinion. There is no real basis on which the witness statements will assist the defendant because it is the evidence given at trial of the action that will be relevant for the determination of the issues and not what was said at the arbitration. This is what Mr. Nelson QC said in his opinion. And so we ask the Honourable Attorney General through you, did the AG consider that in giving this advice, Mr. Nelson was only provided with certain witness statements, that he was not provided with the arbitral award mentioned by the AG. He's aware of that. There were only selected documents that he had before him in committed advice, and therefore did the Attorney General, on discovering that there were documents that Mr. Nelson had not seen, did he consider, in all the fairness and justice of the case, to make these documents available to counsel? And it is to be remembered, at that same time, there was an application by the state before the court to extend the time for the filing of witness statements. She never mentioned that. Says there's the disclosure action, trial is coming, and people start to panic, they start to sweat. In the UNC, somebody is sweating, or let me let you know through you. Unless he has some SSA link inside the UNC offices, there was no UNC sweating about that. The only person who should have been sweating was the AG. He was in charge, he was under care and control. That was the gentleman, that was the office that should have been bent and engaged in prosecuting this matter and not worrying about who's sweating down in some UNC office somewhere. And so, did you consider that the advice 8 minutes was given in this matter was deficient? There was incomplete documentation. And so a responsible AG, in my respectful view, in discharging his duty, would have ensured that if he were going to take a decision, that all the documentation would be available before him and or others engaged in making that decision. And so we believe that it is not sufficient when we look at due care and diligence on the part of a responsible Attorney General to simply parrot the advice of another lawyer. To use that as justification, parrot the advice of Nelson QC, that is your justification for stopping this case. To parrot that advice was certainly okay if you believe that your own expertise and training is insufficient. Well, go get another advice. Dr. Moonilal put it well, and I could put it another way. Honorable Deputy Speaker, you mentioned cancer, and we were discussing this. I mean, you go as a woman and they diagnose you with cancer, and they say you have to cut off a part of your anatomy, because that comes up many times with many women. And do you think you will go do that? Will you go and do that? Just because one person tells you, and he made the point very forcefully, and I want to ask the Attorney General, why was a second opinion not sought? Why? And the fact that a very distinguished luminary, legal luminary, in the person of Mr. Russell Martineau, had initially given opinion in this matter to file proceedings, why wasn't he consulted at that stage before any decision was taken? And I'm hearing muttering, we got a second opinion. But that is ex post facto, because this is the first time hearing of it, that he's muttering. Don't make it up. It is making up as you're going along. Making up as you're going along. I'm speaking to you, sir. The AG has had his turn. I'm speaking to you. And so, perhaps you know, if you know better, I want to tell you, there were several matters in our term in office, and I'm sure there will be many more in yours. A matter of this magnitude deserved, in the public interest, for a second opinion to have been sought. Mr. Deputy Speaker, 6 minutes, thank you. Mr. Deputy Speaker, there are two suggestions I would like to make in terms of the way forward in this matter. The motion is there. We've asked for a resolution to be taken by the House, and we are fully cognizant of the fact that given the numbers in the House is a numbers game, that it will well be that apart from the opportunity we've had to ventilate our thoughts on this matter, that the vote will go along party lines in that way. But, Mr. Deputy Speaker, there is a suggestion I would like to make, and in the matter that Orpuch East mentioned in the United Kingdom, where an Attorney General, a motion of no confidence was brought in an Attorney General for withdrawing a criminal case. And in that case, of course, the numbers game played, party lines and persons voted. But a suggestion was made, and it was accepted by the government, that a joint select committee of the Parliament, and that's what I'm suggesting today, a joint select committee of the Parliament be established with respect to taking and looking and taking into account all the circumstances and all the documentation of this case in the public interest, Honourable Deputy Speaker. And as we say,
members, please. I want to hear the Honourable Member for Siparia.
I thank you, Deputy Speaker. And so, in the 4 minutes I have left, let me just remind ourselves of the grave economic consequences that have hit us as a result of that GTL claim and the other projects that were undertaken under the same players that I mentioned before, the star actors who have returned on the energy scene. When we look at that gas optimization project that they undertook, Honourable Deputy Speaker, the money increased by 561% in the 10-year period, so that the cost of the project rose from 350 billion. I'm looking for the one I have on the, there's one like this. No, it's not it. On WGTL, yeah. 350 million US in 2003 to 650 million in 2005. And by the time you got to April 2013, $1.4 billion. That's the gas optimization project. And so we saw with the WGTL, still looking for that document, the WGTL project. Yeah, I have it here. I'll pass it to you in my notebook if you like it. There you go. You can find it in my notebook. Through you, I'm passing my notebook to the Honourable Attorney General for the citations that he so desperately wants. And so I want to, please, you had 45 minutes of boring this Parliament.
Honourable Member, please, let's hear this, finish your discourse, please.
And the further point, as I close, 2 minutes, the further point is this. I want to give the assurance that in the same way it took us 26 years to find out what happened in the 1990 coup. When we were in government, we ensured that there was a commission of inquiry to get the truth and the facts so that we could work to avoid such a thing occurring. In the same way, we work with respect to what happened with CLICO and set up a commission of inquiry with respect to CLICO, so we could find out what happened and to learn from whatever transpired there. And of course, to bring to justice whomever may be there, whomever might have been wrong. And today I serve notice, Honourable Deputy Speaker, and I'm calling on the government not to hide the Coleman report on the CLICO matter. Not to hide. I heard the answer given to the question asked earlier in the Parliament, and the Honourable Minister of Finance really gave no answer in my respectful view. It was really vague and wish-wash answer that they will responsibly, will consider it responsibly. And it was a clear answer ready to whitewash it, that you want to hide it, that you will not bring it. I will use every instrument in and within the law to ensure that that document becomes a public document. That's the whole purpose of that document. And finally, I say, Honourable Deputy Speaker, the day will come when we on this side will be in government, and I give the assurance that we will launch a commission of inquiry into this entire fiasco containing and with respect to the discontinuance of this case against Malcolm Jones, to bring the truth forward no matter how long it takes. So, Honourable Deputy Speaker, our case has been pleaded with respect to the motion set before this House. We do believe the Attorney General has conducted himself in a manner that has compromised his office in every regard. But further, we do believe the Attorney General has not answered the case made out by the Member of Parliament for Kuchis, and instead took us on along the garden path without answering the specific allegations. So with these words, Honourable Deputy Speaker, I thank you.
Honourable Member for Port of Spain North, St. Anne's West.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, today I rise with a bittersweet taste in my mouth. The sweet part of it is that I have the great pleasure and privilege to rise to support to stand next to and to make out an argument, which is not a difficult one to make, for the honorable member for San Fernando West, who is well recognized, well appreciated, and well respected at the bar of Trinidad and Tobago. Unlike those that may have gone before. The bitter taste in my mouth is that today is going to be recorded in our history as a dark day for Trinidad and Tobago, as this motion can only be accurately and properly described as an abuse of the Parliament, a blatant, transparent, naked assault on the right-thinking citizens of Trinidad and Tobago. I have heard, Deputy Speaker, I have heard attempts to defend live sport, to defend Section 34, to defend the feeding of the trough by a handful of lawyers who took tens of millions of dollars of taxpayers' funds and money by the appointment of none other than one Anand Ramlogan. The level of hypocrisy is sickening, and the call to remove this honorable, respected member of the bar for Trinidad and Tobago by those who actually fired an attorney general due to allegations by none other than a cabinet colleague of criminal wrongdoing. The rest of Trinidad and Tobago will look on today and hang their heads in shame at those opposite. Having started, Mr. Deputy Speaker, I take this opportunity, it being my first opportunity, to state and to put on record, as was pointed out by the Honourable Member for Siparia, I was a practicing attorney at law, advocate attorney at law from 1998 to September 11th, 2015. And one of the cases I did as an advocate attorney at law was none other than this case of Petrotrin versus Malcolm Jones. I was junior counsel for Mr. Jones. Having said that, and the matter was actually one that was done pro bono. Having said that, Mr. Deputy Speaker, I played absolutely no part in the Malcolm Jones matter once I was sworn into office from the 11th of September, which is what this motion, the same person who drafted the motion, who claims to have a law degree, doesn't even understand.
Members, please, address the chair, please, sir. And member, please, the small comments, let's avoid it, please.
Thank you very much, Mr. Deputy Speaker. But I could understand the small comments, because when we look and when I get to the motion, and I show the fallacy of this motion, the misconduct in bringing this motion, the misrepresentation in this motion, I understand the nervousness that is taking place from that side of the chamber. Let me... Thank you very much,
Remember.
Thank you, Mr. Deputy Speaker. I would like to put this matter in some context, please, Mr. Deputy Speaker. This action was an action that was brought by Petrotrin against an individual. This action is intertwined Petrotrin versus one individual, Mr. Malcolm Jones. This action was not an action brought by the Attorney General of Trinidad and Tobago versus the individual who is the defendant. So immediately it is passing strange, and in fact, as has been pointed out by the Honourable Attorney General, it is actually in breach of the company law and other statutes what happened in this matter. The Attorney General can advise any state enterprise, any state company, any cabinet minister, the Prime Minister, any ministry with respect to law. But to take over a matter in the manner that this one was is unacceptable. To reach at the end of the line and have the entity, the claimant, Petrotrin, turn around and say, I do not have a single shred of paper, I have no copies of proceedings, I have absolutely nothing, and no consultation taking place, is grossly negligent. It is a breach of the law, and actually one wonders whether it has actually fallen over the cliff into criminal activity. Mr. Deputy Speaker, I'd like to use this opportunity to share with the public of Trinidad and Tobago, who by and large are lay persons, how this matter should have been conducted. And where it is that you have lawyers, none other than a temporary opposition senator, Mr. Gerald Ramdeen, conducting litigation, fine, but apparently instructing themselves, holding all of the papers, refusing to give copies of the proceedings and other documents to the substantive claimant in the matter, the party that they're supposed to be representing. That reeks to the high heavens, Mr. Deputy Speaker. So, Mr. Deputy Speaker, what we have here is a matter that lacked completely the involvement of the claimant, Petrotrin, and in fact was being driven by an office holder in the face of Mr. Anand Ram Logan, the then Attorney General. And it is quite ironic to hear the Honourable Member from Siparia a short while ago talk about political interference, and talk about political interference in the discontinuance of these proceedings, where the record is clear, the documents are clear, all of the documents reflect that this was a decision taken by the board of Petrotrin to discontinue this matter. And it was not the Attorney General who gave instructions. And that, Mr. Deputy Speaker, is the first fallacy in the motion that is before this Honourable House here this afternoon. Because Oropuch East, who has run out of the chamber, as I expected, who drafted this and who has brought this motion, makes the very serious allegation in the second paragraph, Mr. Deputy Speaker, that this Honourable Attorney General gave instructions to attorneys representing Petrotrin to file a notice of discontinuance. Mr. Deputy Speaker, I put on record here today, there has not been a scintilla of evidence from the other side, and from, in particular, scintilla of evidence, in particular from Oropuch East, the drafter of the motion, to support this very disturbing, distasteful allegation. False allegation that is now shown on the record, because it just is simply not true. The Attorney General, the Honourable Member for San Fernando West, at no time whatsoever gave any instructions to the board of Petrotrin to discontinue this matter. And I will say in a short while why this matter had to be discontinued, in my respectful professional opinion, Mr. Deputy Speaker. In fact, as I get there, I'd like to also put on record the disturbing facts that should be made public and will be made public here. I have been a practicing attorney for 18 years, Mr. Deputy Speaker, and the fees that I've seen charged in this matter by the lawyers are unprecedented. Mr. Deputy Speaker, we had one individual, again a temporary opposition senator, Mr. Gerald Ramdeen, charged $1.2 million. Is there a point of order?
The Honourable Attorney General.
Stand in order, please.
Repetition.
I can understand the nervousness. Thank you very much. Mr. Deputy Speaker, I can understand the nervousness. Let the country take note here today that for the drafting of a statement of claim, not even the filing of the statement of claim, up to the point of drafting a statement of claim, one individual charged the taxpayers of this country, and it was paid $1.2 million for the drafting of a statement of claim. If I say it wasn't done well, I'd be accused of it.
I would say that.
Please, members on both sides, please, let's go ahead.
I'd also like to put on record here, Mr. Deputy Speaker, in 2005, the civil proceedings rules in Trinidad and Tobago changed. And the whole way of doing litigation in Trinidad and Tobago changed. And the Honourable Member for Siparia, who is making her entrance back into court, leading cases now, would be aware of the civil proceeding rules. Two things, two principal points are made with this change in the civil proceeding rules, Mr. Deputy Speaker. The first, cards must be laid upwards on the table. The second is something we call the front loading of matters, which means before filing a statement of case, and the rules can actually be interpreted before even the drafting and settling and execution and sending of a pre-action protocol letter, something the others on the other side love to do. The rules say that when you're sending a pre-action protocol letter, you must attach to it all of the evidence that you intend to rely on. And as a practicing counsel up to the other day, that would also include, if you're doing your job properly, taking of witness statements and what we call witness proofs from the witnesses you intend to utilize to prove your case. Because he who alleges must prove, Mr. Deputy Speaker. So he who alleges must prove means, Mr. Deputy Speaker, before sending a pre-action protocol letter, make sure you have all of your cards lined up. Make sure you have all of the documents lined up. Importantly, disclose those documents to the potential defendants, including those that may not be in your favor as the claimant. And additionally, as counsel of perfection, seek and ensure that you have signed statements from every witness you intend to use to prove your case. Mr. Deputy Speaker, it is unchallengeable in this case, and it is a fact in this case, that they reach the doorsteps of the trial, that is Petrotrin, in February 2016, without a single witness statement. We have correspondence here from Petrotrin, Mr. Deputy Speaker, the claimant, to the attorneys at law, to junior counsel, instructing attorney, asking them, who are the witnesses? How could they have reached the doorsteps of the trial court without documents and without witnesses? And they have the audacity, Mr. Deputy Speaker, to stand here today in the hallowed halls and to try once again to mislead the population of Trinidad and Tobago. Once again to provide complete lies, falsities, and misinformation to the people of Trinidad and Tobago. There was not a single witness statement provided. It had nothing to do with asking for extensions of time, Mr. Deputy Speaker, because when they were requested to do your witness statements, they were asking Petrotrin at that stage, that is the attorneys, who are the witnesses. And Petrotrin put in writing to them as late as November and December of 2015 into January 2016, you attorneys at law, tell us why you're asking us who the witnesses for the case that you have been pushing and doing on your own are to be. And by that stage, of course, the fees of that particular individual had climbed because he had put in another invoice for another $1 million. So $2.2 million in fees at that stage with a case that was going nowhere. Mr. Deputy Speaker, I will say from experience why this had to take place the way it took place, which is the discontinuance. I was also fortunate to be counsel for a number of directors in another case, a case called UTT versus a number of directors. And in that case, it was the same attorneys at law, Vincent Nelson, Gerald Ramdeen, and the same instructing attorney who actually sat, thankfully at that stage of my life, it was the bar table, and they sat there. And we collapsed that case as the defendants in the second day of trial without putting a single witness in the box. And you know what came out in cross-examination of UTT's witnesses? He who alleges must prove. So UTT had to prove the case against former directors. In my cross-examination of the UTT witnesses, they gave evidence to the court. They knew nothing about the case. They gave evidence to the court. They were told by Anand Ram Logan that Gerald Ramdeen, Vincent Nelson were going to run the case. They gave evidence in the case that they had never even seen the statement of case that had been filed. In cross-examination, Mr. Deputy Speaker, what also came out, which was one of the most distasteful times, one of the most distasteful moments in my whole career at the bar, was an accusation by the person in the box of an attorney at law on that claimant's side, the junior counsel, saying and he pointed at him from the box, he is the one that made me sign this. He is the one that gave this evidence and made me sign this. So in that case, Mr. Deputy Speaker, let the records reflect, it cost the state millions of dollars because it went to trial, again, without sufficient evidence. So in this instance, I welcome the attorneys on the other side, starting with the Honorable Leader of the Opposition from Siparia, the mover of the motion from Oropuch East, to tell this House, through you, Mr. Deputy Speaker, and more importantly, to tell every citizen of Trinidad and Tobago how a claimant can go to trial without any evidence. How could a claimant prove its case in a trial without a single witness statement, a single shred of evidence? That is what they're not telling the population. And they paid millions. And in fact, in discontinuing the case when they did, Petrotrin actually saved the state close to $1 million because the case was discontinued before trial. We're not hearing any of that. I would like to say, Mr. Deputy Speaker, again without fear of contradiction, that the type of behavior that took place by the other side in this specific matter of Petrotrin versus Malcolm Jones is a perfect example of professional negligence, a breach of the legal code of conduct and legal code of ethics by the attorneys at law who pushed this case. Because in addition, as I'm being prompted by the Honourable Member for Diego Martin West, in addition, Mr. Deputy Speaker, to the provisions that the Honourable Attorney General quite eloquently laid out from the Legal Profession Act, lawyers are bound in charging fees to ensure that the fees are reasonable for the type of work that has been provided. And to sit here and listen to Oropuch East talk about the complications and the complexity of this matter, I laughed. Because as been pointed out, I was on the other side in this matter. There was absolutely nothing complex. And they should also provide an explanation, Mr. Deputy Speaker, as to why, against the advice of Mr. Russell Martino, Senior Counsel, and at the time Mr. Vincent Nelson, Queen's Counsel, who are both on record in writing in saying to Petrotrin, then under the chairmanship of Mr. Lindsay Gillett, and saying, bring the action, if you may, against all of the directors. Why were all of the other directors dropped? And I'd like to explain that, Mr. Deputy Speaker, through you to the population. A board of directors takes a decision as a board, as a body. The minutes reflect who voted for or voted against, and in most cases, the unanimous decision of the board. Any lawyer worth his or her weight in salt, including a first-year law student, would tell you in an instance where it is a board decision to single out a single board member unless the evidence supports it, and that is the only board member who pushed something that went through and everybody objected, which by definition cannot happen, it is not going to succeed. So to bring a case against one board member when that board member is going to say, well, hold on, this was not my decision, as the documents would reflect, it is a decision of the other 12 members of the board and myself, how would the case succeed, Mr. Deputy Speaker? Again, we're not hearing that. Maybe Oropuch East will tell us what miraculous area of law and his colleagues who fed at the trough for so many years, taking the fees over $1.4 billion, could break through in law to prove this case successfully. But no, unfortunately, Mr. Deputy Speaker, we are brought here today to this House, to stand in this chamber, to waste very, very precious time. But fortunately, it is not a complete waste of time because we are allowed to show the inaccuracies, the misrepresentations, the continued destructive attempts by those on the other side to mislead the population of Trinidad and Tobago. And and I would like to take this opportunity through you, Mr. Deputy Speaker, to put on record this distasteful, objectionable behavior of naming the families of persons who sit on this side is something that the whole country should tell that side is unacceptable. I don't know, Mr. Deputy Speaker. Exactly. A common principle is common courtesy, and it is respect for your fellow human beings. It is not something you see happening from this side to that side. Despite what we may have on paper, there is no attack of your families from this side. But every single week we come here, and there is always a distasteful verbiage coming from that side, and personal attacks of those who don't have parliamentary privilege, who can't stand here and have the privilege of responding to you all. And that, Mr. Deputy Speaker, I'd like to put on record, is the cowardice that takes place. The real multi-million-dollar question, Mr. Deputy Speaker, respectfully, that we should be asking and that should actually be answered by someone on that side needs to answer the population of Trinidad and Tobago. Answer this question. How, after being paid millions of dollars, did the attorneys for Petrotrin, who Petrotrin never even met, not have a single witness statement, and they were on the doorsteps of a trial court? That is the question that needs to be answered. Take millions of dollars, never meet with Petrotrin, say you're going to trial, and then try to excise yourself from the whole process.
Get paid already?
But they were paid already.
Why?
I'd less like to use the opportunity, Mr. Deputy Speaker, to just put a few important facts on the record. On the 13th of October 2011, pre-action protocol letters were delivered to Malcolm Jones, Charmaine Batiste, Garvin Chimming, Gillian Stevens, Ramnarayan Ramdas, Andrew Jupiter, Harry Purty Singh, from none other than Mr. Gerald Ramdeen. The 13th of October 2011, Mr. Deputy Speaker. But we've heard that this action, when finally filed in May 2013, miraculously, surprisingly, surreptitiously, but politically intentionally, if such a word exists, was only filed against one individual. And then they have the audacity to come here and to attack that individual and to attack the decision really made by a whole board of directors and pin it onto one individual. Unacceptable, Mr. Deputy Speaker. Correct. You then have a legal opinion from Mr. Vincent Nelson when there's a change in government and the trial date is very, very close. It's looming. A legal opinion being delivered from Mr. Vincent Nelson, and to his credit, after a proper analysis, and to his credit once again, if credit can be given in these circumstances, he spoke the truth. Kuva, know what you have a problem?
Several.
South?
Several.
You're always babbling down there. You want to add to the
Members.
contribution?
Honorable members, member for Couva South, ever so often you continue to make these comments across the chamber. Please desist. And also, honorable member, please do not take it into your hands. Address the chair, please.
I apologize. I'd like to read into the record once again what it is that the Queen's Counsel, Mr. Vincent Nelson, said on the 11th of October 2015. Yeah, you heard it already. You could hear it again and again. Because if you didn't hear it, you wouldn't have brought this. As mentioned in paragraph 2 above, I've attached the advices originally rendered in this matter. I've considered the contents of and the names were given of the witness statements. I'll pause there. The witness statements, welcome back, Madam Speaker. The witness statements that are being referred to by Mr. Nelson were witness statements that were suppressed. Suppressed, hidden, intentionally, not given by none other than the former Attorney General from that side, Mr. Anand Ramlogan, someone who had to run from office when criminal allegations were made against him by one of his cabinet colleagues. And we're still awaiting the outcome of that criminal investigation. So we have a situation where documents were being requested for in disclosure by the defendant, and he is entitled to those documents. And we now have on record, as been referred to by the Honorable Attorney General, the Queen's Counsel saying, I was in this case from inception. I was not provided with copies of these witness statements. I was not provided with the results, the decisions, the judgments from the arbitration. And it was a frontal point of the defense, Madam Speaker, a frontal point of the defense that disclosure is needed from day one when the defense was filed with respect to these arbitrations. A lawyer has a legal statutory obligation in instances such as that to provide all of the documents, whether they help your case or not. Your legal obligation in law, and in fact you're required to swear an affidavit to that effect, is these are all of the documents that exist. So worse yet, when the defendant on the other side, who you have brought a claim against, says, I need these decisions from the arbitration. You have an attorney general coming right here in this house and making statements about we've been successful, there are arbitration judgments in our favor, but failing to give them, not only to the defendant on the other side, Madam Speaker, but also failing to give those decisions and those witness statements to the same lawyers, his A team that he's hired to prosecute the case. And when they were caught with their pants down at the 11th hour, when they were caught at their pants down at the 11th hour, and it's being passed to me here now, the Legal Profession Act, Part B, mandatory provisions and specific prohibitions. Mandatory. That means there's absolutely no discretion for those on the other side. An attorney at law shall never knowingly mislead the court. An attorney at law shall not withhold facts or secrete witnesses in order to establish the guilt or innocence of the accused. There has never been in my 18 years of practice, Madam Speaker, respectfully, a better example of the breach of these mandatory provisions by somebody, the other side has the audacity to trust upon this country as an attorney general.
And as a senator?
And then to bring us here to challenge a non-decision of the sitting attorney general. So again, mislead the country, attempt to mislead them, and he's back now, so maybe Oropuch East can tell us in this motion, where is the evidence that the Attorney General gave instructions to attorneys representing Petrotrin to file a notice of discontinuance. That cannot be provided because it does not exist, because it is a figment of your imagination. Mr. Speaker, the question is, at this stage, should we look to see whether this has been an abuse of privilege and a privileges motion can be brought with respect to this? So back now to the advice by your hand-picked, your chosen, your silk, Vincent Nelson, where he says, there is a basis for concluding that the Petrotrin board, through bad business decisions, found itself committed to the GTL venture with World GTL Inc. The board was naive and probably duped by the World GTL Inc. principles. Once the board discovered how deeply committed Petrotrin had become, it appears from the witness statements of the two directors, again I pause, the witness statements that were intentionally suppressed by the lawyer on the other side, junior counsel, as well as the then Attorney General, of the two directors, that the company did what they could to protect Petrotrin's assets. I apprehend that Mr. Jones will testify at trial to the same effect. A court may very well find that the decisions which taken to achieve this were bad business decisions. I pause because the member for Naparima earlier, Madam Speaker, was making a lot of noise about the use of the word may. And I am sure, Madam Speaker, that the honourable member for Siparia, being senior counsel and silk, will tell him that any counsel and any lawyer writing an opinion on the likely outcome of a matter can only use that language because you don't know at any level of certainty how an arbitrator and the adjudicating tribunal, in this case a judge, will decide a matter. The only way that you may know that, God forbid, is if you've had discussions at that stage with the arbitrating panel, with the tribunal, or with the judge, which we certainly will never do on this side. So then we go on to say, a court may very well, however, a distinction is to be drawn between bad business decisions and negligence. This is what will engage the court. In other words, that is what the court must decide. Was this a bad business decision or was it negligence? I understand that names given were convincing witnesses at the arbitration proceedings. There is no reason to believe that they will not be equally...
Your 30 minutes are spent. You're entitled to a further 15 minutes if you wish to avail of it.
Yes, please.
You may proceed.
Thank you very much, Madam Speaker. Madam Speaker, and just to finish this point, however, a distinction is to be drawn between bad business decisions and negligence. This is what will engage the court. I understand that names given were convincing witnesses at the arbitration proceedings. There's no reason to believe that they will not be equally convincing in a trial of this action. In the circumstances, there is a reasonable likelihood that a judge will be persuaded that there was a bad business decision, but no negligence. Of course, it's a reasonable likelihood. You can't say with any certainty, Honorable Member for Naparima. This is a matter which the board will need to consider in the context of the future conduct of this action. In addition to the written advice, Madam Speaker, Mr. Nelson availed himself at the state's expense to attend an all counsels, all attorneys meeting with the Honorable Attorney General. And at that meeting, Mr. Nelson orally took it even further than this to say that Petrotrin should discontinue the matter. Petrotrin, of course, unlike what had happened previously, were active participants in this meeting. They weren't locked out by the Honorable Attorney General as opposed to the dishonorable Attorney General before.
Order 48.
What?
Huh? No.
Let him speak.
Madam Speaker, the member 48.
What is wrong with you?
Members, there is a standing order being addressed to the chair.
Come on.
Oh, sorry, okay, let's get it.
Member, I rule against you. This is not, excuse me, members, this is not a member of the House. Please proceed.
Very much, Madam Speaker. Maybe it's a sign of things to come.
Prime Minister, please. Member for Siparia. Member for Port of Spain, North St. Anne's West, please proceed.
Thank you very much, Madam Speaker. Madam Speaker, just to briefly address some of the issues raised by the other side that may be worth addressing. First, the Honourable Member for Orapooch East made reference to the Attorney General of England. Again, I smile, because this particular reference that he made is completely misplaced as usual and completely out of context. The Attorney General in England is a very different creature to the Attorney General of Trinidad and Tobago. The Attorney General of England is actually not a political individual, whereas, of course, the Attorney General in Trinidad and Tobago is. Once again, I am certain he knows it and it was an attempt to mislead.
The right example here. The right example here.
The audacity of calling this and saying it, and of course, Madam Speaker, the cheerleader who's south of him, calling it the audacity of Jones 34. I'd like to say, Madam Speaker, that since we've been in office, Madam Speaker, we found that internationally, unfortunately, the whole vision and the whole credibility of Trinidad and Tobago was eroded, and we're attempting to rebuild that now. So the country is still reeling from the embarrassment of the UNC's government Section 34, something that has been raised with us internationally. He also talked about audits and why wasn't an audit conducted into this. And I'd like to say, Madam Speaker, I'd like to say respectfully, an audit was conducted into this matter. It was conducted by your former Attorney General, by Alex Partners, and it was actually conducted to the tune of 15.4 million. You see the same thing I just spoke about? You can't help yourself. You sit down there and you insult.
Members, maybe there was a little too much sugar Ati, please, member for Couva South. I'm on my legs. Please proceed, member first.
Thank you very much, Madam Speaker. Madam Speaker, so the point made, and as usual, as you are...
Madam
Is this a
Speaker.
point of order?
Yes, ma'am. 48-4. Please protect me.
Members? Members, could we have some order, please? Please proceed.
Thank you very much, Madam Speaker. Madam Speaker, so to finish the point, you said, why isn't an audit conducted into this? I heard the Honourable Member for Siparia say that they will have a commission of inquiry, etc. $31.2 million of taxpayers' money was spent on this, on a handful of their favoured lawyers and an audit firm from England called Alex Partners. And if the best that they could have come with is this particular action, it shows that there was nothing there. But let them continue. And they wanted, yeah, well, we know why they want to continue.
I never see that.
We heard a comment about washing his hands and how this Attorney General washed his hands of the matter. Unfortunately, Madam Speaker, that senior counsel would say this because the Attorney General was not even a party to this matter. It was Petrotrin that was the substantive party to this matter. And in fact, a board resolution was passed by Petrotrin, and I'd like to use this opportunity, Madam Speaker, to just read into the record the board decision of Petrotrin that was taken on the 26th of February 2016 and is here in writing from the Secretary of the Board. Be it resolved that, based on the legal opinions presented before it from Mr. Nelson QC, Mr. Martino Senior Counsel, and the explanations of same presented by Ms. Maraj Adhara Singh, and based more particularly on the second Nelson opinion, which concluded in part that, quote, there is reasonable likelihood that a judge will be persuaded that there was a bad business decision but no negligence, unquote. The proceedings against Malcolm Jones in claim CV 2013-01917, Petrotrin versus Malcolm Jones, be terminated and a notice of discontinuance be filed in the said matter, and that the Attorney General was at all times had conduct of this matter, be so advised. This puts the motion to rest respectfully, Madam Speaker, and once again we found ourselves, unfortunately, being led down a road where there is a continuation of the opposition's assault on the citizens of Trinidad and Tobago and all right-thinking citizens, Madam Speaker. This is an insult to our intelligence. It's a continued attempt to distract, to be disruptive and destructive when this government, Madam Speaker, with the participation of the Honourable Attorney General, are doing what needs to be done to stabilize Trinidad and Tobago, both locally, regionally, and internationally. Madam Speaker, with these few words, I thank you for the opportunity to contribute.
Continue.
I could continue. I have a lot to say.
Talk, man. Talk, man.
Madam Speaker, another matter in this that disturbed me.
Talk.
Realizing, Madam Speaker, that I have a few moments left. I forgot there was one relevant matter I wish to raise for the edification and elucidation of Oropouche East. And this is what disturbed us. We have an email from Petrotrin to the Honourable Attorney General, the Honourable Member for San Fernando West, dated the 4th of January 2016. And what Petrotrin reached out to the Honourable Attorney General on the 4th of January 2016 to say, Madam Speaker, that disturbs us, is it appears that the instructing attorney, Mr. Gerald Ramdeen, Mr. Vincent Nelson, QC, were engaged by the former Attorney General ostensibly on behalf of Petrotrin. Within recent times, the instructing attorney has been seeking instructions from Petrotrin's law department. In response, we have requested sight of all documents. So here we have in writing correspondence from Petrotrin to the Honourable Attorney General asking for his intervention into no other than an important point, Madam Speaker, begging the Honorable Attorney General, the member for San Fernando West, to intervene to get documents that are rightfully Petrotrin's from their own lawyers. And what does the lawyer tell them? The lawyer tells them, in response, this is what Petrotrin is saying. In response, we have requested sight of all documents from him, including the initial instructions to present to the present court order in order to respond to his request. While we have received some documents, Mr. Debadine has declined to provide us with complete papers claiming privilege. Our last request that he supply all papers by December 18, 2015 has gone unanswered. The corresponding email and attachments are attached here too for your ease of reference. Again, Madam Speaker, I forgot to say it. Again, Madam Speaker, in my 18 years of practice, I have never come across a situation where an attorney at law is telling its client, they can call it ostensible or otherwise, but telling their client, because it is not the Honorable Attorney General who is Gerald Ramdeen's client, his client is Petrotrin, and telling their client Petrotrin when they request documents and they request more information and they request simple copies of the pleadings, show us the statement of case. He's been paid millions of dollars at this stage, that they turn around and say, we can't show you the papers. We can't provide it to you. We can't give you anything. We can't provide you anything, Madam Speaker. So, Madam Speaker, with those few words, I'd like to thank you for the opportunity to contribute.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, in accordance with Standing Order 53, I beg to move that debate on this motion be adjourned.
Honorable members, the question is that debate on this motion be adjourned. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Attorney General.
Go ahead.
I rise to deal with the following motion which stands in my name. Be it resolved that the Senate amendments made to the Family and Children Division Bill 2016, listed in Appendix 2, be now considered.
Members, the question is that the Senate amendments made to the Family and Children Division Bill 2016, listed in Appendix 2 to the order paper, be now considered. All in favor say aye. Aye. Any against? The ayes have it. The Attorney General.
Madam Speaker, I beg to move that this House agree with the Senate in the amendments to Clause 41 of the Family and Children Division Bill 2016. Madam Speaker, in the debate in the Senate, two matters were considered by the Honorable House. The two matters considered related specifically in the first instance to a new proposed 41 to be included into the bill. Section 41 of the bill itself referred to the fact that the court, in dealing with the very material improvements to the bill brought under the head of pair resolution, that the court would not permit the inspection of material which related to offenses listed as denying the child the opportunity to proceed to pair resolution. It was an absolute bar. In addition to that, the court also had a second bar in Clause 41, Subclause 2. And in that Subclause 2, specifically, the court was in the position where even though a child did not fall within the scheduled matters which prohibited the offering of pair resolution, the court was debarred if there was a certain violence associated with the child's conduct, and that had been brought to the court. Madam Speaker, it was therefore necessary that we consider that in the round, and members of the Senate felt that it would be appropriate to preserve an ultimate judicial discretion so as to allow the court in all of the circumstances to, notwithstanding the prohibitions of listed offences in the schedule and the prescription against a greater form of violence not scheduled out in subsection 2, to allow the court, in its absolute discretion, in all the circumstances, to allow the child to move to peer resolution. The government felt that this was a very useful purpose. There was unanimous support for it from opposition members and from all members of the independent bench. And therefore, the recommendation to this Honourable House is that we accept the amendments as proposed by the Senate. And so, Madam Speaker, I beg to move.
Member for Princess Town.
Madam Speaker, I'm happy to be able to contribute with respect to the amendment that has been brought to this Honourable House today. Madam Speaker, you would recall when this bill was first brought to the House, we took ownership on this side of the House with respect to this bill, the Family and Children Division Bill 2016, but we would have brought it in another incarnation. Madam Speaker, today we are being asked to support the inclusion of a new proposed clause, 41A, which says, notwithstanding Section 40, the court may refer a child to peer resolution where it considers it to be in the best interest of the child. Madam Speaker, good social skills are critical to successful functioning in life. Conflict resolution is a category of social skills that helps you to positively address conflicts such as dealing with teasing, losing, gossip, accusations being left out, or issues that may arise due to peer pressure. Madam Speaker, it is important that youth develop conflict resolution skills to help them resolve differences of opinion and work through strong emotions before conflict escalates and becomes disrespectful or abusive. The extent to which children and adolescents possess good conflict resolution skills can influence their academic performance, their behavior, social and family relationships. And Madam Speaker, having had this bill been debated before in this House and also in the Senate, there were many considerations with respect to this particular clause, which deals specifically by allowing the court to exercise its discretion with respect to what it considers to be in the best interest of the child. And Madam Speaker, the extent to which children and adolescents possess good conflict resolution skills can influence, as I indicated, their academic performance, their behavior, social and family relationships, which transfers and transfers into how they conduct themselves in society. In terms of the criminal justice system, in terms of their behavior as citizens of this country, and as young people. Madam Speaker, measuring the extent to which you learn to constructively resolve peer conflicts is an indicator of whether or not they have acquired or acquiring the social competence and skills to make choices that will strengthen their interpersonal relationships and facilitate success in schools. Madam Speaker, I've been doing a little bit of research on the issue of peer resolution. And the research indicates that youth who repeatedly exhibit poor conflict resolution skills may experience difficult relationships with adults and peers. And Madam Speaker, when you look at the international best practices and the benchmarks that are used in other countries, I think it's very significant that we as a parliament, legislators, take a look at other jurisdictions with respect to peer resolution. Madam Speaker, I am very happy today to see that some of these amendments are being put forward. Some of these amendments that are now being put forward, Madam Speaker, I believe are in the best interest of some of these children. I believe that when we called for a joint select committee on the Family and Children Division Bill, what it allowed was a ventilation of some of these issues and to address some of the shortcomings in the legislation. Madam Speaker, the peer resolution matter, it allows for conflict resolution skills, as I say, to be able to be dealt with in terms of the experiencing of difficult relationship with adults and peers, which shows higher potential to get involved in the criminal justice system as adults, Madam Speaker, because it transfers the problem as a child into adolescent and then into adulthood. And I'm very happy again to see that many of the proposals that were put forward by members of the opposition and including the independent bench were taken into consideration with respect to peer resolution in terms of this specific clause. Because sometimes in our society today and elsewhere, we have to save them from themselves. And I think that essentially puts this particular clause into context and into perspective. Madam Speaker, assessing a program's success and improving the ability of youth to constructively resolve peer conflict may be done by comparing self-reported data at programs, intake, and exit. Individual level success on the indicator will be a relatively good score on a questionnaire. At the program level, assessing success may be done by comparing responses at program intake at later intervals or at exit. It is also meaningful to compare results for the coherent cohort with those of previous cohorts. Madam Speaker, I want to turn our attention a little to the Chief Justice's support for this peer resolution issue. Madam Speaker, I refer to an article on April 18, 2016, in which the Chief Justice welcomed 118 children into the court-annexed peer resolution pilot program of the judiciary. And Madam Speaker, I'm very happy once more again to see that it has the support of not only legislators, but those that will enforce the peer resolution avenue, that it will now become available. It said that Chief Justice Ivor Archie, in delivering his feature address at a convocation hall of the Port of Spain Assizes, said that the program and its apparent success had deeply touched his heart, as he believed it was a great stepping stone for the restorative justice system in Trinidad and Tobago. And Madam Speaker, while this had been a pilot project, the Joint Select Committee was able to ventilate some of the matters in terms of how this would operate and how this would function, in terms of the longevity of this program, in terms of the future of the program. And Madam Speaker, the Chief Justice went on to say, this is an initiative for juveniles who have committed minor offenses to be granted an opportunity to take responsibility for their actions, learn from their mistakes through skill-building programs proposed by peers, their own peers, and agreed to be a judge and judicial officer. Madam Speaker, the amendment says, 41A, notwithstanding Section 40, the court may refer a child to peer resolution where it considers it to be in the best interest of the child. And what essentially it comes back to is what the Chief Justice is saying in his support for this peer resolution is that we must save them from themselves and allow the court to have the discretion to exercise the authority to send them to peer resolution where it considers it to be in the best interest of the child. And Madam Speaker, that is something we on this side of the House can't support, because we believe that it is an amendment that would provide for the best interest of the children of Trinidad and Tobago, those that are affected, whether it is by family conditions, social problems in the society, at the home, in the school. Madam Speaker, I will refer you to a matter in my own constituency that has given me a lot of an opportunity to reflect in terms of whether or not some of these institutions are really working in the best interests of the children. And Madam Speaker, I have an issue in my own constituency with a child, an 11-year-old child, where the child had committed an act that may be considered to be an illegal act. The child suffers from a condition that was raised in this House by the member for Tawakit, ADHD. And Madam Speaker, that is a proven medical condition in this country. And you would have heard, even on the other side of the House, other members discussing the issue of ADHD and how it affects children. And Madam Speaker, that child in my constituency of Princestown, because of the condition that he has, ADHD, it did not allow him to properly function as any other child would have in terms of exercising their discretion, in terms of what was right and what was wrong, Madam Speaker. And Madam Speaker, today, I'm happy that we are able to contribute to and support this particular amendment, because what it then does, it then allows them to have support from their peers. It allows them to ventilate their own issues by persons who are within their age group, who understand some of the challenges that they face. But at the same time, it does not take away from the seriousness of their conduct or the seriousness of the offense. Madam Speaker, the Honorable Chief Justice went on to say, this is why we are focusing on young people. And throughout the world, you're seeing an emphasis on placing greater responsibility on the state and parents in terms of the support that they provide for young people. Madam Speaker, we on this side of the House have no objections with regards to this particular amendment. Madam Speaker, I would like to turn to the issue. Can I go on to 18E? Okay. All right. Madam Speaker, until the Honorable Attorney General moves on to the Second Amendment, I would like to indicate at this point that we join with the government in supporting this particular amendment because it carefully outlines what we had set out to do while we in government when we brought this bill. And this was the intention. This was the intention of the partnership government through the Honourable Member for Siparia, who has always placed a lot of focus and emphasis on children's rights in this country. Madam Speaker.
Attorney General.
I beg to move that the amendments in respect of the second aspect be now considered. And if I could.
Honorable Attorney General, before you do that, I beg to move and I'll have to put the question.
Yes, ma'am.
Yes.
Well then, let me officially apologize. Beg to move that the amendments in relation to clause 41A be accepted, and I beg to move on that ground.
Honorable members, the question is that this House agree with the Senate in the amendments to clause 41 of the Family and Children Division Bill 2016. All in favor say aye.
Aye.
Any against? The ayes have it. Clerk.
Schedule 5 amended in item 13L, delete 18A and substitute the following. The minister may, by order, for the purposes of DNA analysis, designate a laboratory that is accredited by an international accrediting body. Delete item 13M.
Attorney General.
Madam Speaker, I beg to move that this House agree with the Senate in the amendments to Schedule 5 of the Family Children Division Bill 2016. Madam Speaker, these amendments proposed to Schedule 5 are grounded in the Status of Children Act. The Status of Children Act is being amended in a very important way to move away from a very archaic methodology for determining paternity, which is based upon hematology, and instead accepting the current position, which is best practiced in terms of technology, of using DNA evidence. It is important to note, Madam Speaker, that this amendment is a very significant amendment, not to be confused with the administration of justice deoxyribonucleic acid DNA Act, which was passed in 2011. Usually I say it quite smoothly, but today I've got it wrong. And that criminal realm of DNA analysis, that piece of law, the DNA legislation, is one which contemplates the maintenance of a database, the use of the Trinidad and Tobago Forensics Institute as the designated entity currently in operation to deal with the creation of a data bank for criminal matters. under the Status of Children Act, which is item number 13 in Schedule 5, the amendment is specifically grounded to allow for the civil use of DNA evidence. These amendments are parked immediately alongside amendments to the Police Service Act and other legislation appearing in the schedule, which have the effect of protecting the identity of the children involved, the parties involved, and notwithstanding the fact that we use non-intimate DNA samples in the Status of Children Act, we are specifically putting safeguards so that there can be no undue sharing or breach of information privacy in relation to the information found. In that regard, a specific identification number is assigned to the files. The names are kept along with the identification number. Now, this matter caused a bit of concern in the Joint Select Committee. I don't quite recall the extent of interrogation as put by my learned colleague for Princestown, as he just said a moment ago. In fact, there were no amendments proposed by the members who participated in the Joint Select Committee who came from the opposition at all in relation to Clause 41 or this particular schedule. The point was raised in particular by Senator Sophia Choate, and it is important to address one aspect of this. The aspect raised by Senator Choate was a legitimate inquiry whether one should proceed to have the designation in the Status of Children Act, in the schedule appearing there, of what was referred to as a private organization. There has in fact been some reportage in the newspapers in relation to this issue, and I recall vividly in the Senate, Senator Solomon speaking about a shell company being used. And I wish to correct this. I had offered the caution in the Senate then, but in light of the newspaper reporting, I'm compelled to do it now. The fact is, the judiciary of Trinidad and Tobago recommended the utilization of a particular laboratory. This laboratory, which appeared in the schedule, was one which has... I don't know why members are using their phones so loud.
Members, am I hearing a phone? Could the member with the phone please go outside and make their call and return, please?
Thank you. Madam Chair, I see Dr. Moonilal leaving the chamber now, but anyway. The position is, Madam Speaker, the position is that the comment was made that there was a shell company in operation, and some odium was poured quite publicly onto this entity. Specifically, I wish to put onto the record in this House that the DNA laboratory services offered by this particular entity have been used by the judiciary of Trinidad and Tobago since 2005. The entity's name, in particular, is the Occupational Health Solution Company, which is located at 24 Gaston Street, Lange Park, Chaguanas. And it is a fact that this entity is not only an entity which the judiciary has used since 2005 and the only entity, but it is an entity with international certification from the American Association of Blood Banks, the AABB, the Clinical Laboratory Improvement Act, CLIA, license number 34D09545530, the College of American Pathologists, CAP number 1396901, Siparia, the State of New York Department of Public Health licensure, the accredited to ISO LSE 1725 by ANSI ASQ National Accrediting Board, FQS. Now, I've taken time to put this on the public record because there are active tests being performed by this entity in Trinidad and Tobago, which the judiciary is using, which determine the status of children by a voluntary participation in the Children's Court in the exercise of jurisdiction to deal with children in the family court and elsewhere. And therefore, it is important that people have faith in the integrity of the judicial system. I do it not to defend anyone, but simply to state that they are internationally accredited, that there is balance in this position. Now, Madam Speaker, the other point that I would just like to mention is that this particular amendment now proposes that the minister may, by order for the purposes of DNA analysis, designate a laboratory that is accredited by international accrediting body. And therefore, this particular entity, which is currently in utilization, would, from the information provided and now put onto the public record, obviously satisfy those requirements. The last point that I wish to make is a point which was raised in the Senate and which flows into this debate. I heard a very unusual legal submission by Senator Sturge, where he said, as the member for Princestown did a short while ago, that this bill which came before the Parliament and which we have now was a creature of creation by the UNC government, Mrs. Persad-Bissessar, member for Siparia, Siparia itself. And he said that there was no need to have Schedule 5 at all. Schedule 5, in fact, does amendments to 18 pieces of law, and the position put forward as this amendment is related to it was that there was no need because these are consequential amendments. And any lawyer would know that. I need to put on the record today that that submission is absolutely a nonsense as it comes to the law. The amendments put forward before this House are substantive amendments to 18 pieces of law. The bill brought by the last government amended in 2 pages only, not 88. 3 pieces of law. 1, where they amended the number of judges. 2, where there was a minor reference amendment to the Children's Authority Act, and another small amendment. So there's a very big difference between the work that was produced in the period prior to September 2010 and that which has come before the Parliament now. And it took a significant amount of work effort on the part of the technocratic team in particular to take us there. Having put those measures right, I wish now to simply say, I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to Schedule 5 of the Family and Children's Bill, Division Bill 2016.
Madam Speaker, I'm very happy that the Honorable Attorney General went into... I'm happy that the Prime Minister is admiring my new suit. Madam Speaker, certainly not from you, sir. Certainly not from you. Madam Speaker, I'm very happy. Certainly not from you, sir. Madam Speaker, I was very happy to hear the Honorable Attorney General raise some of the issues that was ventilated in the Senate with respect to this particular amendment. Madam Speaker, we are being asked to support this amendment, but I would like to go into what existed before this amendment was brought. And 18A in the schedule says, 18A1, Occupational Health Solutions Limited of 24 Gaston Street, Lange Park, Chagonas, telephone, etc., and it went on to say, would be the designated laboratory. That clause has now been replaced, and it says the minister may, by order, for the purposes of DNA analysis, designate a laboratory that is accredited by an international accrediting body. And I heard the Honorable Attorney General speak about the advancements and the proposals and solutions that was proposed by members of the Joint Select Committee from the opposition. And I want to remind the Honorable Attorney General that when I, as a member of the Joint Select Committee, specifically asked who was a company that was being designated, the Honorable Attorney General responded by saying that he did not know. He then went on to ask members, and that is in the verbatim notes of the Joint Select Committee. He went on to then ask members of the committee and those who had appeared before the committee, including Ms. Stephanie Daly and others, about which company or what was the name of the company. And Madam Speaker, I will put that in context later on as I go along, because as I develop this specific point. Madam Speaker, the Honorable Attorney General spoke about international accrediting. And Madam Speaker, for any organization that conducts DNA testing, one would hope that they do have the proper international accrediting. Madam Speaker, the global leader in developing technical standards for industrial, commercial, and government fields, ISO 17025, one of the most prestigious certifications in the DNA testing industry, is awarded to laboratories which exemplify technical competence in all calibration and testing activities. Madam Speaker, demonstrating the laboratory's commitment to providing premium DNA testing services, the laboratory is pleased that they would have had formally received accreditation under ISO standard 17025, placing the laboratory as one of the first few full-service private DNA paternity testing laboratories in the world to receive accreditation. Now, Madam Speaker, that is what any DNA testing facility aspires to. Madam Speaker, before I go into some of the other issues that the Honorable Attorney General raised, I would like to look at the issue of fully accredited laboratory services and what are some of the issues. Now, there are many organizations in Trinidad and Tobago that provides DNA testing. And Madam Speaker, I was very fortunate in my research to be able to speak with the former president of the Trinidad and Tobago scientists, laboratory consultants, who was able to ventilate some of the points that I would like to raise in terms of these DNA companies that are set up in Trinidad and Tobago and do these sort of work and testing. Madam Speaker, I want to turn to the issue of what do you look for when you're looking for one of these international accrediting agencies as described in 18E. Madam Speaker, you look at the references. You look at the references in terms of the organizations that they are associated with, in terms of whether or not they have linkages with international organizations that are properly constituted and properly regulated in the field of DNA testing. Madam Speaker, you look at the scope, the standards that describe the quality assurance requirements at a laboratory, which is defined as a facility in which forensic DNA testing is performed, should follow to ensure the quality and, most importantly, the integrity of the data and competency of the laboratory. Madam Speaker, that is another issue I will turn to in a little bit with respect to the integrity of these samples that one would take at any DNA facility right here in Trinidad and Tobago in order to maintain the integrity of the samples being sent abroad. Madam Speaker, it also deals with definitions in terms of these standards. The administrative review, the amplification blank controls, which consists of only amplification reagents without the addition of sample DNA. And if, for those who are in the medical field, and you know, while we speak about reagents for DNA testing at some of these laboratories, which is actually needed, Madam Speaker, would you believe at the San Fernando General Hospital and the Princestown Health Facility, for months they have been going without reagents and therefore they are not even able to complete blood tests. So, Madam Speaker, I'm just linking into the points on the issue of reagents and bringing it up as a matter that is in the public domain that I'm very, very concerned about. I know my colleagues from Faizabad and Barataria San Juan looks forward to raising this as a substantive issue about the lack of medication and reagents.
To this particular amendment.
As I go back to the particular amendment, I promised to raise several issues with respect to what the Honorable Attorney General spoke about in terms of the concerns of members of the opposition bench and members of the independent bench. And Madam Speaker, I want to publicly congratulate members of the opposition bench in the Senate and the independent bench for not allowing themselves to be an accessory to a travesty that would allow a private company to be enshrined in our legislation. And Madam Speaker, had it not been for Senator Wade Mark and Senator Sophia Choate, some of these matters would not have been ventilated with respect to this particular amendment. And we go back again to the international accrediting body. Madam Speaker, I recall in the Joint Select Committee, at no time can I recall the members of the judiciary explicitly saying that they wanted this particular agency to be enshrined in law. They had indicated to us since 2008 to now they had been utilizing this agency. Madam Speaker, there are several questions I would like to pose to the Honourable Attorney General, including questions also to the member for St. Joseph, the Minister of Health. Madam Speaker, the Honourable Attorney General had indicated that this was an agency that had been used by the judiciary. He just said to us again that this was actually something that was asked for by members of the judiciary and the judiciary. Madam Speaker, Occupational Health Solutions Limited, the company that was bandied about in the media, in the Senate, in terms of persons not being comfortable with this particular company being the only company being enshrined in law. This particular company is not the only company in Trinidad and Tobago that facilitates, and I want to make that point, Madam Speaker, because when I spoke to the president of the Trinidad and Tobago Laboratories and Scientists Association, who deals with this sort of DNA testing, I was advised that there is no organization, there is no body privately that deals with DNA testing in Trinidad and Tobago. What they act as a facilitator with respect as a mailbox service for agencies abroad. And therefore, while we talk about international accrediting body, Madam Speaker, I want to raise companies, not only Occupational Health Solutions Limited. I want to raise the issue of CureMed, Lab Medical, Victoria Labs, St. Augustine Private. These laboratories have been acting as a facilitator, separate and apart from Occupational Health Solutions Limited. To say that this is one of the few only will be untrue. And Madam Speaker, what we are asking is that these companies be given the same access and the same consideration as Occupational Health Solutions Limited. And Madam Speaker, I saw in the Senate the AG was at pains to explain why. And it was almost as pulling teeth. The Senate had to be suspended for over 30 minutes because of this Occupational Health Services Limited. And Madam Speaker, that company has been in operation for about 7 to 8 years. And similarly, many of these other companies have indicated, CureMed, Lab Medical, Victoria Labs, St. Augustine Private, they have been in the industry for years. Madam Speaker, I am concerned, and I would like really to know where this proposal and recommendation is coming from, and why was the Honourable Attorney General advancing a private interest in the Parliament of the Republic of Trinidad and Tobago. Madam Speaker, it raises the question of whether or not the Honourable Attorney General did due diligence in terms of...
Just to caution you a bit, the amendment seeks to remove occupational health. It doesn't seek to put any other agency in it. So I would really like you to come back to what the amendment is and confine your contribution to that, please.
Madam Speaker, I am so guided. Madam Speaker, it was the Honourable Attorney General who raised the issue of the Occupational Health Solutions. And I will move on, except to say, Madam Speaker, that while government advanced the interests of this particular company in light of the issues regarding procurement legislation, so on, that was brought by the People's Partnership Administration, one would think that the Honourable Attorney General will have done his homework with respect to internationally accredited bodies. Madam Speaker, Madam Speaker, the issue here is whether or not the Attorney General, the Honorable Attorney General, completed his due diligence with respect to advancing this particular interest of a company. Madam Speaker, while there are many other organizations and companies that deal with DNA testing, did the Honorable Attorney General contact his colleague? And sometimes we know they speak to each other, sometimes they don't speak. The left hand doesn't know what the right hand is doing. But did the Honorable Attorney General speak to the Honorable Minister of Health, asking for the Ministry of Health to go in and do quality assurance with respect to these agencies?
There's no agency mentioned in the amendment. And therefore, if you could, it is a designated laboratory that is accredited by an international accrediting body.
Just asking, in future, the Honorable Attorney General, in terms of the minister being able to designate, or by order, that we do, if we are utilizing these local agencies as a mailbox, that we utilize the services of the Ministry of Health and others to do the due diligence with respect to the quality assurance. Madam Speaker, as I wrap up on this particular issue, I want to caution members of the government that when you were forced, because you did not have the support of the opposition or the independent bench, to bring this particular amendment, that you look into the conduct and the affairs of some of these companies. Honorable Attorney General, do you know that Petrotrin, Trinma, and Nestle has discontinued its service?
Member, I am on my legs. I will caution you again on relevance. This is not about Petrotrin or anything else. Please get back to the amendment.
Madam Speaker, we on this side of the House were very happy to be able to support this particular amendment because of the fact that it brought us a lot of concern with respect to who, when, why, and how. You heard an electrician being a director in a particular company, and we are looking forward, Madam Speaker.
Member, this is the last time I'll caution you. Please deal with the clause.
Madam Speaker, as I said, we are very happy because it brought us a lot of concern. But Madam Speaker, when you're looking at giving the minister by order for the purposes of DNA analysis to designate a laboratory that is accredited by an international accrediting body, I would hope that the Honorable Minister with that responsibility will look at persons who are specialists in the DNA field, persons who are specialists in the molecular biological field, and not those, Madam Speaker, who have just opened up these shell companies to act as a facilitator where someone is getting government contracts, Madam Speaker, and it is taxpayers' money that we are dealing with, Madam Speaker. Taxpayers' money. And we just heard about $3 billion down the drain with Malcolm Jones. We just heard about it, Madam Speaker. And this, again, is the responsibility of the Honorable Attorney General. You may not like to hear it. You may not like to hear it, but you came to this Parliament in a joint select committee, advance the special interest of a company belonging to a soca artist. Do you even know that? So it's now soca.
Member. This is the third time I've cautioned you. I am not cautioning you again. I'm asking you to take your seat.
Madam Speaker, I don't think I've ever heard a contribution as melodramatic and as repetitious and as irrelevant and as contrived as the last one. Madam Speaker, for the record, the amendment before the House, moved by the Senate,
Removes the lab.
is one which says the minister may, by order, for the purposes of DNA analysis, designate a laboratory that is accredited by an international accrediting body. For the record, the entity previously named in the schedule will clearly, from the certifications that I have put onto the record, automatically qualify for use. Secondly, I don't know where Princestown gets this idea about tax-paying dollars. Tremo.
Remember, this type of behavior, this type of behavior is not going to be tolerated. Okay? We're not at a boxing match where people is not going to be tolerated. The other thing is, when I stand, I expect all members to observe the standing orders and maintain silence. Attorney General.
Thank you, Madam Speaker. I am told that constriction in clothing may sometimes cause anxiety. It may perhaps be good. We loosen up a little bit. We loosen up a little bit. Get a little bit calm. Yes, Madam Speaker. The fact is that the particular amendment before us is one which permits any laboratory to be so certified. The last speaker, the Honourable Member for Princestown, made a wild allegation that tax-paying dollars are being used. The manner in which entities are paid under the legislation certainly does not involve an expense where the judiciary pays in every circumstance, or the parties pay through the tax-paying dollars pocket for paternity testing. I don't know where the member for Princestown gets it, and I'd like to put on the record, the member for Princestown who served on the committee, signed the report, attended 5 sessions, had absolutely no contribution to make other than on the LGBT issues in decriminalizing homosexuality, which is a legitimate
That is
issue.
absolutely untrue, Madam Speaker. Absolutely.
Member, I've cautioned you. Minister of Finance, as a senior member, I don't think I should have to caution you with respect to the decorum. Member for Princestown, if I have to caution you one more time about the short and across, as if we, as I say in the boxing ring, I will have to invoke my powers under the standing orders. Continue.
Madam Speaker, I was saying, the Honourable Member for Princestown and Senator Khadija Amin contributed on the committee. We held 5 meetings. The only substantial amendment proposed by the Honourable Member for Princestown was squarely the decriminalization of homosexual activity amongst children enveloped in the LGBT rights issue. The government of Trinidad and Tobago informed the Honourable Member that the issue would be dealt with by way of consultation and analysis, and that the Constitution in the meanwhile applied. So I don't know where the member for Princestown is going with the histrionics
Would the Honourable Member give way?
In getting into business about how much contribution was made or not made on this particular entity and what was said. Because the record will show that the member signed the report, had very little to say, and therefore it betrays 90% of his contribution today.
He signed the report.
So I really just don't understand the histrionics of the Honourable Member for Princestown. Madam Speaker, again, for the record, the issue of designation is one which is done upon recommendation. in Section 14, Section 13 of the Status of Children Act as amended by item number 13 in the Schedule 5 to the bill, that will show that the Status of Children Act is one which deals with recommendations for testers coming from the registrar and marshal of the court. The Attorney General is a mere facilitator of the process. The Attorney General has nothing to do with listing or licensing anybody inside of this particular process. Obviously, we will be guided by the recommendations of the judiciary as we were in this particular point. Now, for the Honourable Minister, Honourable Member for Princestown, to raise the issue of promoting some private entity's interest, which he calls a shell company, is a far-fetched, far-flung postulation on the part of somebody who just doesn't understand the process. The order is particularly clear. It says that the minister may make a designation of any entity which survives the process. The rule and substance of it is that it is done by way of recommendation from the judiciary. The rule and substance of part of Section 13 and 14 of the Status of Children Act as amended is that the registrar and assistant marshal, assistant registrar, assistant marshal can engage in the process of recommendation. That's actually quite a simple process. I wish the honourable member to simply be guided by the judiciary's involvement in this exercise. I heard him shout across the floor, which is no doubt recorded into Hansard, tell us about buildings, etc. It is important to recognize the judiciary of Trinidad and Tobago in relation to this amendment has its autonomy. The judiciary of Trinidad and Tobago has selected entities. The judiciary of Trinidad and Tobago in the period prior to the general election engaged in the selection of buildings and other resources for operationalization of this bill. And no amount of histrionics, shouting, screaming, or making it up by the member for Princestown is going to change the fact that the judiciary of Trinidad and Tobago is the driver of this process. You see, they have a habit of liking to pour scorn on everything that comes across their plate. And I want to put it and mark the spot squarely today. Don't try that foolishness when the records can speak for themselves with the greatest of respect, Madam Speaker. In those circumstances, I beg to move.
Madam
Honourable Member, is this on point 44.8? After he's completed? Honourable Members, the question is that this House agree with the Senate in the amendments to Schedule 5 of the Family and Children Division Bill 2016. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to Friday, the 1st day of July 2016 at 1:30 p.m., at which time we will be continuing debate on the anti-gang and bail amendment bills.
Honourable Members, the question is that this House now do adjourn to Friday, the 1st of July 2016 at 1:30 p.m. All in favor say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Friday, the 1st of July 2016 at 1:30 p.m.